Article 5 is the part of the Constitution that dictates how amendments can be made to the Constitution. And don't get me wrong, the founders intended for there to be amendments to the Constitution from the very beginning. Don't forget that the Bill of Rights itself was an amendment. It was 10 of them, actually. Okay? Amendments were supposed to happen. So they said how we could get our amendments. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of the Constitution, when ratified by the legislatures of 3/4 of the several states, or by conventions and 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress. Now, we could break that down, because if this is the first time you've ever seen Article 5, you might be going, say what? That's probably what I did the first time I looked at it. So let's break it down. What this is saying is that there are two paths to amend the Constitution, two ways you can do it. And there's an important reason why there's two ways, and we will talk about that. The two ways to amend the Constitution are: one, U.S. Congress can introduce, debate, and vote on an amendment. That amendment will then be officially proposed. Okay, so when we say U.S. Congress, we're talking about Washington, D.C. That means the House has to introduce, debate, and vote on it, and the Senate has to introduce, debate, and vote on it. And if they both agree, and 2/3 of both of them agree, then that amendment is officially proposed, not passed. Congress cannot amend the Constitution. All they can do is propose an amendment. That proposed amendment then goes to the state legislatures, all 50 of them. Those state legislatures then vote. If 38 of the state legislatures, that is the 3/4 required, 38 state legislatures all say, yes, we like this amendment, then the U.S. Constitution is officially amended. What's the second method? Well, actually, let me back up a minute. This is great. This is efficient. What's the problem with this method? The problem with this method is that the only people who get to have input are the federal government. The federal government is pretty far removed from you and me. I don't know about you, but I don't talk to the person who's representing me in Washington, D.C. all that often. That's a long ways out, and they don't come home very often. So, or at least if they do, they don't come and talk to me, right? If you try to get them on the phone, that's not going to be easy. These people in the federal government, they don't talk to us very often. They're really far removed from us, and they have an interest in maintaining any power that they have. And that is the reason why the founders put a second method into the Constitution, because they had a conversation when they were writing up the Constitution. And what came out of that conversation was the question, do we really think that if the federal government steals power it's not supposed to have, that it will ever propose to give that power back? And the answer was no. They had just fought Britain. They knew that a tyrant never wants to give power back. It was a unanimous agreement to add a second method, therefore, to the Constitution for proposing amendments. Second method: 2/3 of the state legislatures can pass a resolution to call for a convention to propose amendments. All right, so what's different? Instead of Congress proposing the amendment, it is the state legislatures that say, hey, we want to get together and propose an amendment, something that is coming from us, not from the federal government. This is important because they can propose things that they want to impose on the federal government that the federal government is never going to propose to impose on itself. Propose to impose. That's too much O's. Let's keep going. All right. So if 2/3 of the of the state legislatures pass a resolution calling for a convention, the convention is officially called. Each of the 50 states will send commissioners to this convention. At the convention, they will introduce, debate, and vote on amendments, same as Congress would do. If the majority of the states present like the amendments, those amendments are officially proposed. Again, important to note, the convention cannot amend the Constitution any more than Congress can. All it does is propose amendments. Those proposed amendments are then sent back to all 50 state legislatures, who then vote on those amendments. If 3/4, again, 38 states, a very high bar, like any given amendment, they are then added to the Constitution. The Constitution is considered amended. All right, so those are our two paths to amending the U.S. Constitution.